this side. Are we ready? Okay. I'm going to call to order this Board of Adjustment meeting for April 22nd, 2015. Could I have the roll call, please?
Mr. Alahouzes?
Here.
Mr. Boris?
Here.
Mr. Elliott?
Here.
Mr. Hassick? Mr. Roboski?
Here.
Chairman King?
Here. Okay, now we'll have the quasi-judicial announcement.
Good evening. This is the Board of Adjustment meeting for the City of Tarpon Springs. The Board of Adjustment is a quasi-judicial board of the city, and in a quasi-judicial hearing before the board is required to make findings of fact based upon the evidence that is presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The board may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has met the criteria established in the Code of Ordinances, then the board is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinances, then the board is required by law to find against the applicant. There is an established procedure which will be followed at this quasi-judicial hearing. All witnesses must give their testimony under oath. All persons testifying at this hearing must give their name and address for the record. All testimony and questioning at this hearing must address matters that are relevant and material to the issues under consideration. The city will present its testimony and evidence first. The applicant may cross-examine the city's witnesses. The applicant will then present its testimony and evidence, and the city may cross-examine the applicant's witnesses. If necessary, the city will then have an opportunity to present rebuttal evidence or witnesses. Members of the public opposing the application will be given an opportunity to present testimony. After all members of the public speaking in opposition to the application have presented their testimony, members of the public in support of the application will have an opportunity to present testimony. Each member of the public is limited to 4 minutes of testimony. The applicant will then have an opportunity to make any closing argument or summary, after which the city will be given an opportunity to make its closing argument. Anybody here who wishes to speak on any of the matters that are scheduled for this evening's hearing, please stand and raise your hand. Do you swear to tell the truth on all the matters before the Board of Adjustment here this evening?
I do.
All right, thank you. When you come to the podium up here to speak, please state your name, your address, and that you've been sworn for the record.
I guess, are we doing that yet? Because do we have any approval of minutes? I don't see it on the agenda. I have one set of minutes here, but they're not set up for my signature.
We actually don't have that on this evening's agenda, so we can wait until the next meeting for the approval of any minutes.
All right, that's fine. Okay, so then we'll move on to application 15-11. The city, please give its presentation.
Thank you, Mr. Chairman, board members. This variance is for Lot 1 within the Ganoy Park subdivision. This lot is located at the southwest corner of Lakeview Drive and Butler Court. Lot 1, this subdivision was approved in 1926. The property is zoned R70A, single-family residential. This zoning district requires a street side setback of 15 feet. And within the Land Development Code, there's a requirement for the construction of sidewalks along all improved streets. The requested variance tonight is for a side street setback of 7.5 feet in lieu of the required 15 feet, and a request for a waiver of sidewalk construction. Section 215.02B of the Land Development Code establishes the criteria for the grant of a variance. In analyzing these criteria, staff has found that the variance is based on the physical nature of the property. This lot, Lot 1, was platted with a width of 52 feet when the current standard is a lot width of 60 feet. We find that the lot, it is not a self-created hardship as the lot was platted in 1926 and is considered a legally non-conforming lot. And we find that literal enforcement would deprive the applicant the ability to build a reasonably sized and configured home on the property. We also find that the variance will not confer any special privileges to the property owner or adversely impact the surrounding area, since the intent is to construct a reasonably sized single-family home in a neighborhood intended for such type of development. So staff does recommend approval of the setback to the side street. Sections 13201B and 13201C, those sections established criteria for evaluation of a waiver to sidewalk construction. In analyzing these criteria, staff has found that there do not appear to be any physical or design conditions that would prevent construction of a sidewalk on this property. We find that there is sufficient right-of-way along both streets, 50 feet for Lakeview Drive and 25 feet exists for Butler Court. And while sidewalks are not present in the area, the Land Development Code does not permit this condition to be a consideration in whether to grant a sidewalk waiver. As such, given these findings, staff does not recommend approval of the waiver for sidewalk construction. Notice for this variance was placed in the Tampa Bay Times, was mailed to surrounding property owners, and posted on the subject property. Staff did receive several inquiries on the project, but no formal opposition has been received. With that, Mr. Chairman, that concludes my presentation. Staff will be available for any questions.
Okay, does the applicant have any questions of staff regarding the presentation we just heard?
No, sir.
Okay. Does anybody on the board have any questions of staff? Okay. Please state your name and your address for the record and go ahead and let us know any information you think we need.
My name's Torrey Cooper, and 310 Leafwood Road, Tarpon Springs, Florida. And I'm here to answer any additional questions that the staff or the board may have in regards to the presentation.
Okay, does staff have any questions?
No, sir.
Okay, does anybody here on the board have any questions for the applicant?
Go ahead. Go ahead, you were first.
No, that's okay.
The question that I have is on Section B is why you're requesting to, for the sidewalk waiver. What's the reason that makes you to feel that it's not, you don't need to have it?
In regards to the sidewalk, sir?
Yes, sir.
Well, our waiver request was in the fact that there are no sidewalks in that neighborhood, and then after conferring with staff themselves, that's not a justification for a waiver on the sidewalk, so we will go ahead and waive that issue as far as the sidewalks.
Okay.
So you're withdrawing the application for the variance for the
Yes, sir.
sidewalk?
Yeah, we're withdrawing the application.
Just
on
for your
variance.
information, Tori, I believe the ordinance permits you to either construct the sidewalk or put the funds in a trust fund for sidewalk construction.
That would be our anticipated plan, is to set
And-
aside.
And there is a figure in this code, I believe. Is that correct, Steve?
Mr. Chairman, board members, that is correct. A rough calculation for this lot would be, it is basically, the fee is a calculation based on an ADOT index, and that comes out to $15.55 a linear foot of sidewalk. A quick calculation for Lot 1 is it's a little over $2,000, $2,083 would be a rough estimate.
Okay, did you hear that, $2,000 in lieu of the construction? Something like-
Yes, sir.
Okay. If I may, Mr. Chairman, last month, this item came up, and I declared a conflict because I thought that I should not vote. I did prepare a deed for the Fackless family. That's the deed we're talking about for this property. But that was 3 years ago. I do not currently represent the Fackless family. I had no knowledge of this application, and of course, no participation in the preparation of the application. And I think based upon that, since I'm here, I have to vote. So I'm going to vote on this application. I haven't decided how I'm going to vote until we hear from everybody, of course. Mr. Cooper, do you have any kind of rendering of this house you're planning to build? If not, can you describe what you're going to build?
No, sir, I did not bring a rendering of the house, but the house itself would sit in a footprint that would be no larger than 40 foot wide and approximately 65 foot deep. It'd be a two-story home, is what it would, which would concur with the existing homes in the neighborhood.
Two-story concrete block, wood?
It'd be
or-
concrete first floor, frame second floor. Yes, probably most of the styles we've looked at so far in a Key West style exterior.
Any idea what the price range would be for this house?
I think you'll be looking at probably about the $275,000 range, starting.
That's all I have, Mr. Chairman.
Okay. Are there any other questions for the applicant? Okay, is anybody here to speak in opposition to this application? Okay, is anybody here to speak in favor of the application? Okay. Does the applicant, would you like to make a closing statement at this point?
No, sir.
Staff, do you have a closing statement at all at this point?
No, sir.
Okay. I'll open it up to discussion amongst the board.
Well, I would like to speak about, in regards to the setbacks. This is a unique situation with a lot, is not conforming lot, and it was plotted way before the dimensions were actually required. So I think it makes sense to give them the opportunity to build on it and give them the setbacks that they're asking for.
Anyone else? Okay, I'll take a motion.
That'll be my motion as well.
Okay, so you're saying your motion is to...
My motion is to approve the request on the setbacks from 15 to 7.5.
Okay, I have a motion. Do I have a second?
Second.
Okay, and vote?
Mr. Alahouzes?
Yes.
Mr. Boris?
Yes.
Mr. Elliott?
Yes.
Mr. Roboski?
Yes.
Chairman King?
Yes. Okay, thank you very much.
Thank you.
We'll now move on to application 15-12. Staff, if you could give us your presentation. We're done.
He's on this one.
Can I
Oh,
stay
it's
here?
yours also. All right, sorry. Then we're not done.
Thank you, Mr. Chairman, board members. This is Lot 10 within the Noy Park subdivision. Basically, is a little further west down Butler Court from Lot 1, the case we just heard. Located at the corner of Sunshine Drive and Butler Court. Property is also zoned R70A, single-family residential. Zoning requires a street side setback of 15 feet. And again, for this request, there was a request for a sidewalk waiver, and the Land Development Code does require a sidewalk along all improved streets. Requested variance for this lot is for a side street setback of 7.5 to 10 feet in lieu of the required 15 feet, and that request for sidewalk waiver. Again, Section 215.02B of the Land Development Code establishes the criteria for the grant of variance. In analyzing these criteria, for Lot 10, staff finds that the variance is based on the physical configuration of the lot. While platted with a lot width of at least 60 feet, the way this lot was platted is it does narrow in the middle to where if all of the setbacks as applied were to be used, the applicant would be left with approximately about 35 feet at the narrowest point. So that was the physical constraint that we looked at with this variance. We find that it was not self-created as the subdivision was platted in 1926. We find that little enforcement would deprive the applicant the ability to build a reasonably sized and configured home on the lot, and that the variance would not confer any special privilege to the property owner or adversely impact the surrounding area, since the intent is to build a single-family home on a lot within a single-family zone surrounded by other single-family homes. So staff is recommending approval of the side street setback, but we are recommending that the 10 feet be required for this lot. Sections 132.01B and C establish criteria for the evaluation of a sidewalk waiver. In analyzing these criteria, staff finds that there do not appear to be any physical or design conditions that would prevent construction of a sidewalk on the property. That sufficient right-of-way does exist to accommodate the sidewalks. And that, again, while sidewalks are not present in the area, the Land Development Code does not permit this to be a consideration on whether to grant a sidewalk waiver. Given these findings, staff does not recommend approval of the sidewalk waiver. A notice for this variance was placed in the Tampa Bay Times, was mailed to surrounding property owners, and posted on the property. Staff did receive several inquiries, but again, no formal opposition to this variance has been received by staff. With that, Mr. Chairman, that concludes my presentations. Available for any questions.
Do you have a presentation to make on this one?
No, sir, it'd be the same as the other one. But Steve, we're talking about 10-foot setback, correct?
Yes.
Yeah, versus 7.5.
Are you waiving your request for the
Yes, sir,
sidewalk
on the
variance this
sidewalk.
one also? Okay. I guess we can, are there any questions for the applicant on this one? Yeah.
Okay, I'm not clear exactly what the variance request, is it for 2.5 feet? Instead of 10 feet, it'll be 7.5?
No, the variance that they're requesting is actually, it's 15-foot regularly. We're requesting it back down to 7.5 feet is what we're requesting.
On which side or both sides?
That would be on the street side. This is side yard setback.
Okay, yeah, if you could get on the microphone, Mr. Cooper, and show, because we get on television too, and everybody needs to hear what's going on. So can you take it back to the podium or?
No,
Just show us what you're doing, if you could. Can you
If
bring
you
that?
take the drawing with you, sir.
You need to speak on the microphone so the television can hear what you're saying.
CNN or some other television show.
So there's two streets.
Tori, you need the microphone, I believe.
How about that?
That's better.
I'm not used to this. This is Butler Court, and then this is Sunshine Drive here. The variance we're requesting is on Sunshine Drive, which is a side yard. The side yard of the house could have been on either side, here. So there's 25, which is the normal setback in the front yard, and we're requesting a 7.5 foot here, which normally would be 15, but because the actual property line bows, and it was extremely hard for our surveyors to actually come up with the meets and bounds out there 91 years ago to actually, so that's why in the variance you'll see we request between 7.5 and 10 foot. So it gave us enough to actually fit a 40-foot wide pad in there.
When you say 7.5 and 10, that's where I get confused. Is it a 7.5 or 10 or both? Or Steve?
7.5 is what we prefer.
The 7.5 foot variance.
Yes, sir.
You're asking for a
Out of 15,
7.5
yes.
foot side yard where a 15 foot is the code requirement.
Correct.
Okay.
But the city is asking for 10, right?
Mr. Chairman?
Yes.
May I ask the staff, Steve, can you tell us why you recommended 10 feet instead of 7.5?
Mr. Chairman, board members, the application, they had requested between the 7.5 and 10 feet for this lot. And in looking at this lot, given that it did have, compared to the other lot, it did have a much wider footprint, this lot. It does bow in the middle, but given, in looking at trying to provide the minimum variance, we felt that a 10-foot would provide enough relief. So the staff recommendation was the 10 feet in lieu of the required 15, which would get the applicant enough room on this lot.
Mr. Chairman, may I
Yes.
ask the
Yes.
applicant? Sir, being that this is a non-conforming lot, are you going to have enough square footage to actually build a house if we go with a 10-foot sideback?
Yes, sir.
Thank you.
Yes.
Hate to run this in the ground, so it's a 5-foot variance, the way I look at it. The variance is a 5-foot difference from what the code requires. Well, I have the floor. Mr. Cooper, could you again explain what kind of a house you plan to build? Is it the same thing exactly?
Yes, sir. This should be a 2-story dwelling. You'll have a 2-car garage into it. It's approximately 2,200 square feet. So it'd be block on the first floor and it'd be frame on the second floor.
Thank you.
Okay, are there any other questions? Okay, is there anybody here to speak in opposition to this application? Is there anybody here to speak in favor of this application? Okay, I will open it up. You don't have a closing statement again, I would imagine?
No, sir.
Okay, and staff, you don't have a closing statement?
No,
either?
sir.
Okay, I will open this up to discussion amongst the board. Does anybody have any discussion on this matter?
Well, he's already admitted that he can build with 10, so 10 seems like the city's recommendation that we should go with.
Okay, and if nobody else has any discussion, I'll accept the motion.
I'll start. I'll make a motion that we approve the variance of 5 feet on the side, this would be on the sunshine, And there is a question about the fence that Chris has raised. We ought to talk about that perhaps at some point.
Okay, that's fine.
Okay. So I move that variance be approved, a 5-foot variance.
Okay, I have a motion.
Second.
I have a motion and a second for a 5-foot variance. Could we have a vote, please?
Could we have discussion, please?
Oh, you want, oh, okay.
Can we, as an explanation, say that the variance now is going to be, the side back is going to be 10 feet instead of 15? So there will be no confusion on that, for the record.
The setback.
Yes, sir.
Yeah. And there is a fence in the middle of the right-of-way.
Correct.
Any idea whose fence that is?
Excuse me, is this part of the application, or we've done it with the application? It
We
appears,
have a motion and a second that we're going to vote on in 1 minute, but the board had some questions.
it appears that Butler Court, I think the attached survey to your application shows it, but it appears that there's a 15-foot encroachment from Tarpon Salem Tennis Club that's right in the middle of the Butler Court property.
So the answer to my question is it's not Mr. Fackless, not the Fackless family. It's Lake Tarpon Sale and Tennis has a fence that encroaches into the right-of-way.
Yes, sir.
So I would presume that the Public Works Department is going to address that issue. All right.
Yes, sir, at the TRC meeting, when we discussed both of these variances, this fence was discussed. It was determined that it was most likely, none of the city staff were able to say this is not a city fence. It was likely belonging to the condos to the north, that development of the property, when the road is improved, that's the time that the fence would be moved. It would be the responsibility of the developer to move that fence as part of their road improvements. If our utility staff did not think we had any utilities or structures in the way, if there are at that time, that would be our responsibility to move, but they did not think we had anything obstructing the road.
But we have nothing to do with the fence. That's a city staff issue, and it may have been a permit for that fence or a license to encroach.
Well, even if not, if it has not been objected to in 10 years, they own that property now, right? Is that not the case?
No.
If they encroach into the right of way with,
Not necessarily.
No.
There's a lot that you have to meet for an adverse possession claim, and they would have to show basically that, rights were not asserted against it and that it was continuous, open, notorious, and some other criteria that probably does not meet at this time. It does seem that if it is in the right-of-way, it would be a potential code enforcement issue and can be removed by those means too as well.
So the issue of this fence doesn't affect the variance we're voting on right now, is that correct?
No, it does not.
Okay. Could we go ahead and, it's okay, go
I
ahead.
believe that the law is, from my other hat, that there is no right of adverse possession against local governments, so there's no right that Lake Tarpon Sale would have to claim that portion that they've used for the last however many years it's been.
Correct.
Okay, could we go ahead and have a vote?
Mr. Alahouzes?
Yes.
Mr. Boris?
Yes.
Mr. Elliott?
Yes.
Mr. Roboski?
yes.
And Chairman King.
Yes. Okay, your application's been approved. Thank you very much.
Thank you.
Okay, we're moving on to staff comments. Does staff have any comments?
Mr. Chairman, board members, no comments at this time. Just thank you for your time this evening.
Do any board members have any comments they'd like to present?
To be verbose, I was watching the television just to see how I can improve my efforts here, and it seems like we all can do a better job of being on the microphone. It's hard to hear the television replay. Not that you want to see yourself on television, but just for the record, I think it'd be a good idea if we can try to use the mics more often.
Did you look good in it? No. Okay.
Any other comments?
Fortunately, that didn't show.
Okay. This meeting is adjourned.
Thank you, gentlemen.
You look good.
So when does
It's always on the chairman. I don't know why.
I actually don't
Just
think
at the
it's
neighbors?
10 years. It's like 15.
Look, I heard Yakubon say it right here. I was sitting right over there. I'm not kidding you. I heard him say it. That doesn't make it true.
Yeah.
My man, Yakubon.